Honorable Senators, I rise today to speak on Senator Griffin's amendment to Bill C-6, an act to amend the Citizenship Act. Senator Griffin, I really respect what you had to say yesterday, genuinely, and I'm hoping after this all is done that you and I can work together to improve services of language training around our country. I often go to Quebec and I see the kind of training that Quebec government gives to immigrant women, especially refugee women. They provide, not only do they provide training, they provide a wage and they provide babysitting, and if your child is sick, they provide somebody to look after your child. That's when one can learn training. So there is a lot of examples across the country where women can learn English, but it's a slow process. So I hope to work with you in the future. I know that all who immigrate to our great country want to speak either English or French, or in both of our official languages. They wish to speak with their fellow Canadians. My grandmother came here at the age of 99 when we were refugees. And she was so frustrated. She said to me, at home, my first relative was my neighbor. I could walk up to my neighbor and knock on their door and ask to borrow sugar. She really wanted to learn English. I buried my grandmother the following year at the age of 100. Unfortunately, she never had learned English. So without language, immigrants cannot even communicate with their neighbor, much less borrow that cup of sugar. When I came here to this country 42 years ago, I was in absolute disbelief when I learned that the federal government did not offer lessons in either of our official languages to women. At that time, women were seen as people who were not joining the workforce and would therefore not need to speak English or French. In response, a few years later, a number of us women joined together across the country and formed a national organization, the Immigrant and Visible Minority Women. And we also formed provincial organizations for the express purpose of forcing the federal government to provide language classes to immigrant women. What was wonderful about this experience, and I often think about it, is that on the one hand, we were taking on the government, and on the other hand, Minister Crombie from Toronto would teach us how to get organized, to teach us how to write letters to the Prime Minister, would teach us how to go about getting language lessons for immigrant women. We were not successful, and as a result, we took Prime Minister Mulroney and his government to court. As a result of this court action, instruction of English was provided for immigrant women. Honorable Senators, I do know how important it is for Canadians to learn English or French. My mantra at that time was, how can I borrow sugar from my neighbor if I cannot speak English? However, over the years, I have learned that learning a new language becomes difficult when we reach an older age. Honorable Senators, I personally know this. You all know this as well. As Senator Petitclerc very eloquently said yesterday about how difficult it is for us to learn languages. As those of us who are trying to be bilingual in the Senate know how hard a challenge that is to learn another language. At a young age, around me, I learned 6 languages. But it wasn't like it was a big deal. That's what we did. But at this age, I can't even learn French fluently. It is not that I don't want to or I'm not able to, it's just not as easy. As a result, my views have shifted. I have learned that beyond even learning French or English, being able to call Canada your home is the most important thing. When you belong to Canada, when it is your home, you want to build your home and see Canada flourish like any citizen would. While I always believed that borrowing sugar from my neighbor is important, I now believe that borrowing sugar from your fellow Canadian is even more important. Together, we can work together to continue building this great country. We all need to belong. We all need to feel that we are Canadians, regardless of the difficulties we may face. When I questioned Senator Griffin about her amendment, she said that provisions discussing compassionate grounds would cover exceptional cases where immigrants face challenges learning one of our languages. Honorable Senators, as you know, compassionate grounds is not covered by Bill C-6. Secondly, humanitarian and compassionate grounds is covered by Senator McCoy's amendment, but that term only applies in instances of revocation for misrepresentation or fraud. Thirdly, I found that only place where I found compassionate grounds was in Section 5.3 of the Citizenship Act, whereby the minister can use their discretion to have any citizenship requirement, including language requirements, waived on compassionate grounds. While it may seem that it covers these exceptional cases, I carefully read the law, and policy behind it actually shows that this section of the Citizenship Act is very limited in its application. There is considerable evidence to show this. First of all, a 2016 Policy, Procedures and Guidance memo from Immigration, Refugee and Citizenship Canada actually outlines how compassionate grounds can be used. These grounds focus primarily on extreme cases like those of physical or mental disabilities, rather than the circumstances that might be present in a person's life. For example, a deaf or a mute person would fall under this category. When you apply to have requirements waived on compassionate grounds, it states in this form, which is on the internet, it states that the applicant has to provide a medical opinion or an audiology report in the case of people who are entirely deaf. Honorable Senators, the policy here is clear. Compassionate grounds only apply for people who suffer from mental or physical disabilities that make it implausible for a person to learn one of our languages. Even beyond the policy documents, I went and searched the case law last night to see if there was some definition of compassionate grounds. The most recent case that actually touches on this issue is Kantasamy versus Canada Citizenship and Immigration case, which appeared before the Supreme Court in 2015. While the case does not directly examine Section 5.3 of the Citizenship Act, instead looking at the Immigrant and Refugee Protection Act, it does look at how another law interprets the words compassionate grounds. Since the term being examined remains the same, the law still applies. In their ruling, the Supreme Court stated that compassionate grounds involve situations where it would impose unusual hardship on an individual or place them in an extreme situation. Some of the examples the court provided were factors in their country of origin. This includes but is not limited to medical inadequacies, discrimination that does not amount to persecution, harassment or other hardships, health considerations, family violence considerations, consequences of the separation of relatives. Honorable Senators, once again, even the court sets out very limited scenarios where compassionate grounds can be used. It is only applicable for the most extreme of scenarios where fulfilling a requirement to become a citizen is not plausible for the person in question. Having looked into the policy, having looked into the law, and having searched last night to see if I could find anything else on compassionate grounds, everything I read said compassionate grounds was in an unusual situation. As we studied C-6 before the Senate Standing Committee on Social Affairs, Science and Technology, we heard from witnesses who brought their considerable experience to us. So I went first to the citizenship site, and I've given you what the citizenship site said. I then went to look at case law, and I've told you what case law said. So then I went to the next source that we were presented with in the committee. Enavi Yayogo, clinic director of the Metro Toronto Chinese and South Asian Clinic, appeared before the Senate committee. Ms. Go is a very respected lawyer, and she has often come to our committees. She has often presented to our committees. She works with immigrants every day and truly understands the issues they face. In particular, she has represented some of the poorest and the most vulnerable immigrants. Ms. Go articulated how difficult it can be for some of her clients to pass the language requirements and how damaging it can be to not be a citizen. I believe that her explanation of the plight of one immigrant woman will provide a strong example of how inflexible our current system can be when considering compassionate grounds. Ms. Go's client came with her husband and had 4 children here in Canada. Her husband was able to become a citizen because he passed the language requirements. However, due to postpartum depression and minor health issues, it was not as easy for her, and she failed the English test. When that happened, she tried applying on compassionate grounds by submitting a doctor's report to say she had issues with learning English. A citizenship judge accepted her circumstances, but the Citizenship Department and the Department of Justice appealed the case, believing that the medical report was not enough. This woman was forced to go see Ms. Go and fight for her Canadian citizenship. This is how Ms. Go describes the case, and I'm quoting her. We went to the federal court and tried to convince citizenship again, based on the information that we have about her medical issue. The whole thing takes about 3 years. In the meantime, she's doing her job just like any other woman. She's raising her kids despite her disability. She was trying to work part-time in a restaurant to help support her family and was trying to integrate at the same time. That's why she wanted to become a citizen. It doesn't matter how hard she tried, she was not able to pass the citizenship test. She then goes on to talk about how damaging this was for the woman. And she goes on to say, and I quote, "As I mentioned, she has depression and the sense that she is treated differently from the rest of her family. She feels she is not accepted as part of society, as an equal, which also adds to that depression and anxiety as well." Close quotations. When Bill C-6 proposes loosening the language restrictions based on age, it considers cases far beyond those considered by compassionate grounds as set out in the Citizenship Act and as mentioned by Senator Griffin. C-6 considers cases like this of the woman who has worked around the clock for her family while struggling with health issues that made it difficult but not impossible to learn one of our languages. Rather than relying on exceptions like compassionate grounds, we must allow our laws to actively account for the cases like the woman that Ms. Go spoke about. Honorable Senator, je parle maintenant de mon expérience à apprendre le français, en comparaison avec l'apprentissage de mes enfants et de mes petits-enfants. Mes enfants et mes petits-fils sont bilingues. Ma petite-fille et ma belle-fille seront bilingues sous peu. L'autre jour, ma petite-fille de 3 ans s'adresse à son grand-père en lui partageant son inquiétude. Comment fera-t-il pour discuter avec lui s'il ne parle pas la langue française? Pour mes enfants et pour mes petits-enfants, apprendre le français est une tâche plus facile. Ils sont jeunes. Pour mon époux et moi-même, ce fut une lutte ardue, comme je le sais pour tous les individus unilingues dans cette chambre. J'ai appris que l'idéal est que nous soyons tous bilingues ici et nous avons tous tenté d'apprendre une langue seconde. C'est pour cette raison même que je n'appuie pas l'amendement de la sénatrice Griffin, puisque je souhaite que toutes les femmes... Can I have 5 minutes?
Is it agreed, honorable colleagues?
Thanks. Thanks. Que toutes les femmes qui appartiennent à notre pays et désirent devenir canadiennes ne soient pas oubliées simplement par un manque de capacité linguistique en français ou en anglais. Je crois que nous sommes tous ici enfin d'aller emprunter une tasse de sucre chez votre voisin, et j'y tiens. Nous, nouveaux arrivés, veulent tous avoir un sentiment d'appartenance et notre rôle à titre de sénateur et de sénatrice est de répondre à cette requête. Honorable Senators, it was a few weeks ago when I was doing a French lesson and my little granddaughter was sitting there and she was listening to me and she was learning. And that's when, as I said in French, she turned around to my husband and said, "You're the only one who's not going to know French." And he looked at me and said, "What have you started? At this age, at 74, I'm not going to learn French." But what I'm trying to say to you, it's not that people do not want to learn English or French. It comes at a time when you don't have the ability. And to those of you who have doubts whether you should grant citizenship to a woman or a man who's 55, let me tell you, as somebody who is privileged to have had given that citizenship paper, that when you become a citizen, it is a paper of freedom. When I'm a citizen, I can walk down on Spark Street. I have the same rights. If my boss doesn't treat me right, I can complain and not lose the right to be sent home. If I have issues in my home, I can walk away and not suffer a violent situation. And most importantly, I can proudly say I am a Canadian. Thank you very much.
Senator Jaffer, will you accept a question? Senator Cordy?
Thank you very much, Speaker. Yesterday, when I was explaining the wonderful refugee family that I visited many times and the challenges that the parents were having in learning the language, and when I explained to the sponsor of the amendment, and she said, well, perhaps because they're trying hard and they're taking the lessons, that they could become Canadian citizens because of compassionate grounds. But I was jotting half notes down when you were speaking. You said that those who could receive citizenship who don't speak the language, that it's very limited, Section 5.3, I think you said, and that from all the research, and I'm sure that both you and Senator Omnivar have spent the past 24 hours reading and doing more research on this amendment and also on the bill, so I greatly appreciate the time that you both spent on this. But you did say that it was very limited and that all of the research that you have done showed that you could only get compassionate grounds to receive citizenship if you didn't know the language because of physical or mental disabilities, that you would have to have a medical opinion from a doctor, undergo a hearing test. Is that, I wonder if you would expand on that, I guess would be my question.
Yeah, I was surprised because when I actually admit I felt quite stupid when I asked Senator Griffin the question and she said there were compassionate grounds, and I thought, oh my gosh, this is a question you shouldn't ask if you don't know the answer. And so I was going to go along with what she said, because if there's compassionate grounds, then what's the issue? We can change the age. When I went home, and when I went back to the office, and when I did research, and I found that compassionate grounds only apply if there's a medical or physical disability. And as Ms. Go said, she's gone to court and has not succeeded. So compassionate grounds just for medical and physical disability is not really compassionate grounds. And there are many other reasons. You know, Senator, as many of us know, that To learn French is hard enough for me, but at least the alphabet is the same kind of alphabet. And you know, the first thing the first thing I learned was all the same words that are English and French. That doesn't exist if you come here from the Middle East. That doesn't exist if you come here from China. That doesn't exist if you come here from India. The alphabet is different. Everything is different. It takes longer. And so for me, when you talked about what the compassionate ground would be, can I just finish 2 sentences?
2 sentences.
Thank you. Is that what the person who comes here at the age of 55 brings is they complete the family. And if the family is happy, we are happy. Thank you.
Thank you, Senator Jaffer.